The country's extended lockdown has forced several industries to do business differently. Now, many have been itching for the current lockdown to be lifted as it has badly affected their income. But the concern for many is whether they have appropriate contractual rights to protect themselves during this period. Can a company invoke force majeure and avoid paying workers? Well, let's discuss this further. We're joined by Osborne Mulatudi, who is an employment and labor law specialist at Mulatudi Advisory Services. It's good to have you with us this evening. Now, it's not a question. COVID-19 has naturally affected many contracts nationally as well as internationally. But does the law make a provision for such circumstances, particularly as it governs the relationship between employer and employee?
Thank you, and thank you for having me on your show. Yes, the common law doctrine of force majeure applies to all contracts, and that will include employment contracts. So in other words, there is a mix of relevant principles insofar as commercial agreements are concerned, as well as employment contracts. I will focus on the employment implications because that's the area that I specialize in. So as a starting point, all of us will recall that the President made a call on 9 April 2020 that during the extended lockdown, an appeal to employers is that they should not invoke force majeure, simply because there are a number of options that are available to those employers who may wish to terminate employment agreements as a consequence of force majeure. And put it simply, force majeure simply means that there is a supervening impossibility on either or both of the parties to perform in terms of the contract.
So Osborne, talk to me about those conditions in detail. I mean, there's 6 that I have seen. I'm sure there are more conditions that would trigger a force majeure. But explain to me, this one, it says the impossibility must be objectively impossible. What does that mean?
It means it should be something that neither party foresaw, neither party contributed to it, neither party have anything to do with it. It's something that one can describe as beyond one's control. In other words, act of God. That is why it's sometimes loosely referred to as act of God. So it simply means that. So in this circumstance, no one foresaw that there will be, at a certain point in time, a coronavirus which may result in a pandemic and a lockdown in which we find ourselves. So that's what it basically means. However, in the context of employment contract, I was advising some of our clients that it will be challenging for them to find any clause in any of the employment contracts making reference to force majeure. And simply because our labor laws have got avenues which can be followed by employers when there is an inability by either party to perform in terms of the contract. One of which can be incapacity, the other one can be retrenchment, temporary layoffs, or simply a normal dismissal, which must then be preceded by fair reasons to be advised to the employees.
So not entirely out of bounds, but it's going to be difficult for an employer, for example, to go for that route, because most employers will say with COVID-19, one of the conditions is that it must not be a fault of either party. So it is not my fault, it is not your fault as the employee, but as you're putting it, it is an act of God, and therefore I can no longer be able to discharge my obligation, and therefore I want to be, I suppose, excused from this liability.
Indeed, indeed. We must keep in mind that the Basic Conditions of Employment Act defines remuneration as an aspect which is paid by an employer in return of hours worked by that employee. Now, in a situation where an employee is not able to render those hours of work to that employer, consequently, it means that the employer is not obligated to remunerate that employee. So there has to be a bit of a balancing act between the employer as business viability versus the employee's expectation to be paid remuneration. And what I'm explaining is just basically on general principles. However, we now know that our government has put in place options that are available to employers who may not be in a position to pay remuneration or call it full salaries to their employees during this lockdown period.
So then you're saying employers then can't just discharge themselves from their liability. They have now, under law, got to pursue those avenues that have been made available.
It will be very challenging for them to sustain that withdrawal. It will be very challenging. As I said to most of our clients, they will search in vain if they find a force majeure clause in any of the employment contracts for their employees. Yeah. So the best option is, of course, to temporarily lay off employees or to retrench them altogether if they can't afford to pay their salaries.
And what do you suggest is the route to take if that's the option that you want to go for? Sorry to come in there. What do you suggest is the route to take if that's what you want to follow legally?
Our advice is that if an employer is in financial distress as a result of this pandemic, the best option is to temporarily lay off employees, subject, of course, to the requirements that are set out in our labor laws in terms of engagement, consultation, and trying to obtain representation from employees in terms of ways in which the layoffs can be avoided. But under this circumstance, one doubts that there will be other alternatives except for the reduction of working hours and the reduction of salaries. What is important is that even under that circumstance, the employer will be expected to make an application on behalf of affected employees to the COVID-19 TERS relief scheme, where it will require the government to come to an assistance. And that has been made available. I mean, a lot of money has been set aside for this purpose, which we are told is about 10 billion as we speak, and the government is anticipating that it may increase that. So, yes, the best option will be if the employer does find itself in extreme financial distress and not able to pay its employees their full salaries or any, then that's the route to go, to temporarily lay them off, but at the same time to explore the option that the government has made available to them.
Osborne, we appreciate your time. Thanks for joining us. Employment and Labour Law Specialist Osborne Muladudi there, outlining for us conditions that would be followed by employers during this time.